Getting arrested is confusing and it's scary. The number one focus after an arrest is to get released. There are 3 different ways to post bail: cash bond, which means to pay the whole bail amount, or a bail bond, which means paying a percentage of the bail amount. Lastly, a personal bond. But this is at the discretion of the judge at the jail. For most people, this is the ideal way to get out of jail. But there are some cases where a bail bond is the better solution. So while a PR bond is very appealing as opposed to paying any part of bail, posting a bail bond comes with less conditions than a PR. During magistration, an arrestee is given information from a judge about his or her charge and the bail amount. If the judge doesn't say there are any conditions with bail, depending on the charge, it might make more sense to post a bail bond rather than try to get released on a personal bond. Judges tend to order more conditions when a PR bond is concerned, and there are a lot of ways a person can mess up. However, for most people, a PR bond is the preferred way to get out of jail. But here are the worst case scenarios that a judge might tack on as a condition of your PR bond without your consent. For substance abuse related cases, a counseling assessment will more than likely be ordered. This would require a visit to Travis County Counseling and Education Services, better known as TSES, where they will conduct an evaluation to see what classes they recommend. While these classes are a recommendation, a closer look at the PR bond condition order form states that the following conditions are part of said order, and be prepared to pay $55 for this assessment. Another condition that will be ordered for a felony drug possession charge is drug court screening. Travis County has this intensive program that someone could potentially qualify for depending on criminal history and the admission of a drug problem. Successful completion of the program means an outright dismissal of the case. While this sounds great, it's an extremely rigorous program that will last at least a year. It is very difficult to be accepted into. Any mess-ups mean an extension, and an approval from both the prosecutor and the judge needs to happen before anyone can enter the program. Lastly, violence-related cases have their own set of conditions that could be ordered if someone elects to get released on a PR bond rather than going through a bail bond. Another TSES evaluation for counseling will more than likely be ordered in addition to a potential anger management class. In addition, safety-related conditions include no contact with the victim, 200-yard stay-away order, or a stay-away order from an address. Supervision could be added via a PR bond. A supervision condition means the arrestee must report to a pretrial services officer for an office visit once a month. Having a job is a requirement, and proof of employment needs to be provided. Plus, any out-of-state travel must be approved by the judge beforehand. This condition can be ordered for any kind of offense, violent or nonviolent. If mental health issues have been diagnosed and documented, there is a unit that is devoted entirely to mental health supervision. More at-risk conditions require the use of surveillance devices to be ordered upon release. A condition called electronic monitoring, or EM, or called house arrest, requires the defendant to stay at home for the entire duration of their case. These defendants have to report to pretrial much more frequently than supervision clients, and they cannot leave their house unless their officer gives them permission. An approved work schedule is established, but beyond that, only the pretrial officer can decide when and where they go to. Another monitoring condition that could be ordered is Global Position System or GPS device. While this allows arrestees to move about freely while out on bail, it's essentially a tracking device. A pretrial officer will monitor every move they make, alerting the court if the defendant travels anywhere they're not supposed to, or if they go to a particular place that might raise suspicions of potential criminal activity. Both EM and GPS could be ordered to be installed in jail. That means even if bail has been posted, a defendant can't get released until they have one of these ankle monitors attached to them first. A stable, verified address is required for both, and an initial payment for the GPS must be made. While EM is free, a GPS monitor will cost about $300 a month. And a DWI can come with its own set of conditions. If someone has been convicted of a DWI, no matter how long ago it was, an ignition interlock device, or IID, will be ordered as a condition of release. This is required by law and is something that will be enforced no matter how a person gets released from jail. The arrestee must pay to install this device in their car within 21 days of release. They will have to blow into this device to even start their car, and every 10 or 15 minutes as they're driving. It costs about $100 a month, and the defendant must report to pretrial and follow every rule in the program. Outside of those, there are other conditions that might be added on a PR bond. Random UAs, supervision, no driving without a valid driver's license, or a curfew. Also, if people get arrested for the same charge, no contact with co-defendants could be ordered. If someone gets out of jail on a personal bond and doesn't like the conditions that it comes with, they can change that to a bail bond right away and avoid all the conditions that are not on the order of commitment. An order of commitment is the official paperwork of the magistration process. It has the offense charged, the bail amount, and any conditions, and whether someone requests a court-appointed attorney or they want to hire their own. But if an arrestee violates their PR bond conditions and gets their first bond revoked, then the additional conditions will be added on top of the new order of commitment on the second bond. There are no ways around these new conditions at this point. Here are some example situations where someone might consider getting out with a bail bond rather than a PR bond. An assault family violence charge. There may be no conditions ordered with a bail bond, but a judge granting a PR bond will feel safer signing it if the judge elects to add a no contact or 20-hour stay away as a condition. Well, what happens when that address is the defendant's home? Where do they live once they get released from jail? The reality of not contacting this other person can be so difficult that it makes it impossible. Drug possession charges with random UA as a bail bond can be extremely inconvenient. Not only does it come with being supervised and having to report to pretrial monthly, it means that whenever the officer calls someone to go to a UA, they must go. There will be a call or email in the morning from the officer, and the client will be expected to show up at some point that same day to give a sample. If they don't show up, it'll count as a violation, and the judge can decide to revoke their PR bond. DWI, for someone who hasn't been convicted of one, shouldn't be required to install many conditions. But if there is an accident, high BAC, or a young person in their 20s, think again. If there are circumstances associated with getting a PR bond, a judge might feel safer ordering an ignition interlock device as a condition. Although for most DWIs, sometimes the prosecutor will file a motion to add this IID device as a condition under community safety reasons as well. The bond conditions that are ordered, for the most part, are to last the entirety of a person's case. There are pros and cons to both personal and bail bonds as ways to get released from jail. PR bond is free, while bail bond will cost money. Sometimes getting released on a PR bond is the only option because bail bond is too expensive. With that though, there could be certain conditions that are added to a PR bond that must be followed as long as the case is pending. Depending on the conditions someone could potentially be facing, it might make more sense to opt to pay the percentage of the bail amount to have the potential freedoms that come along with the price of a bail bond.